The witness protection challenges in the country impacting the status of some cases before the courts. This revelation made by the Attorney General, Senator the Honorable Carl Bethel. He was sharing concerns while speaking in the Senate this morning on several bills, including the Criminal Evidence or Witness Anonymity Bill. The Attorney General recalled incidents where witnesses were murdered, homes were invaded, and families terrorized. He explains how the impact is still being felt.
Cases cannot go forward right now because of these concerns. It is in the best interest, and the 2011 Act provides adequate safeguards. The judge has to be requested. The judge has a statutory duty, which the judge would exercise in any event, to balance the interests of justice against the right of a jury, ordinarily, to see and assess every aspect of the witness. Now, because the face is hidden and the voice is disguised, doesn't mean that the jury won't be able to assess things like, movements and pauses and other things. But the judge assesses based on the seriousness of the charge, the nature of the offense, the submissions by the prosecution, submissions by the defendants. He does the weighing and balance.
Now, Mr. Bethel noted that in the amendment, once the judge makes a decision regarding protection, he or she is mandated to give specific warnings to the jury regarding the evidence in the case.
The Constitution of the Bahamas requires a fair trial. There's nothing about this amendment that will make a trial unfair, because the witness is still subject to cross-examination in front of the jury. The witness is still liable to have their evidence weighed in the scales by the jury. And at the end of the day, we think that this bill is necessary in the public interest and in the interest of the due administration of justice.